Does the Constitution protect your right to love, but stop short of protecting your right to marry? On 17th October 2023, the Supreme Court answered this difficult question. This date became a landmark moment in the Indian constitutional history. On this day, a 5-judge constitution bench of the Supreme Court of India delivered its judgment in Supriyo at Supriya Chakrabarti versus Union of India. For the LGBTQ plus community, this case carried enormous hope. It asked a deeply personal yet constitutional question: does the Indian Constitution guarantee the right to marry the person you love? The verdict was not the complete victory many were hoping for, but it opened an important national conversation on dignity, identity, and the limits of judicial power. The court's central finding was clear. There is no fundamental right to marry under the Constitution of India. While the judges acknowledged that marriage is an important social and legal institution, they clarified that the right to marry is a statutory right and not a fundamental one. In simple terms, marriage exists because the Parliament has created laws for it, not because the Constitution guarantees it by default. The court also drew a firm line on its own powers. It stated that creating a new legal status, such as civil unions or same-sex marriage, through a judicial order would amount to judicial legislation, something only Parliament and state legislatures can do. A major challenge in this case was against the Special Marriage Act 1954. The petitioners argued that words like husband and wife should be read as gender neutral, meaning spouse, to include same-sex couples. However, the majority of the bench refused to read down the act. They held that the Special Marriage Act was structurally designed for heterosexual relationships, and changing its language would create a ripple effect across multiple laws, including succession, adoption, and divorce. Simply put, the court said if marriage laws are to change, that change must come from the Parliament. One of the strongest parts of the judgment dealt with the claim that queerness is a Western or urban elite concept. The court categorically rejected this argument. It observed that queer identities have existed in India since ancient times, from references in Rig Veda to temple art to literary traditions like Rekhti. The bench also noted that many petitioners came from rural and working class backgrounds, making it clear that identity is not limited by geography or class. There was, however, a significant recognition by the court. It affirmed that transgender persons in heterosexual relationship have the legal right to marry under existing laws, including personal laws. This means a trans woman and a cis man, or a trans man and a cis woman can legally marry in India today. On the issue of adoption, the bench was divided. Chief Justice D.Y. Chandrachud supported the right of queer couples to adopt jointly, but the majority upheld current CARA regulations which require a stable marital relationship for joint adoption. So where does this judgment leave the LGBTQ plus community? While marriage equality was not granted, the court recorded an important assurance from the union government. A high-powered committee chaired by the cabinet secretary will examine a range of practical rights for queer couples, including joint bank accounts, pension benefits, insurance, and nomination rights. The court concluded on a reflective note. The shadow of Section 377 may be gone, but the struggle for full social and legal equality is still going. As Justice Sanjay Kishan Kaul observed, this is not the end, it is the beginning of a new journey. Thank you so much.